1970, our firm has represented tens of thousands of workers' compensation clients here in Nevada. We hope we can help you too. First, the most important thing to understand is the requirements of a workers' compensation claim. What does it entail? First, you have to have an accident that occurs in the course and scope of employment. If you don't have that, there is no claim. Of course, the accident has to result in an injury. It's not enough that you just tripped. You actually have to be hurt too. A workers' compensation claim also has two components to it. It contains the notice, what we call the C1, and that has to happen within the first 7 days of a workers' compensation injury. And then the C4 form. That document has to be filled out within 90 days of the injury. Failure to timely provide notice or failure to timely bring the claim can result in the insurance companies denying your claim. Even if the injury really happened, you really got hurt, all you did was blow the timelines. If you do that, you'll lose your claim. I'm often asked, what benefits do I receive if I file a workers' compensation claim? I mean, why even do this? There's a schedule of benefits that you're entitled to under the Industrial Insurance Act. We'll get into them in more detail, but they generally are medical benefits without any copays, travel expenses, short-term disability pay, permanent disability pay, a lump sum award, and vocational rehabilitation benefits. With regard to the medical benefits, it's important to remember there is no copays, no out-of-pocket expenses associated with your workers' compensation medical benefits. There's additional benefits that you need to understand. Most importantly is the ability to select your doctor. This is key. It's key because if you have a bad provider taking care of you, they can derail or harm your claim. So selecting the right doctor in the first 90 days of your claim is absolutely critical. Another important thing to remember about your medical benefits is every time you visit your medical doctor, you can't leave without a piece of paper. That piece of paper is called the PPR, the Physician's Progress Report. On it, it has all kinds of information. What the doctor has done today, what he or she wants to do down the road, and what benefits that you're going to receive in the interim, and how long it is until he or she's going to see you again. Do not leave the doctor's office unless you have that in your hands. If you do, you'll regret it. It's common for doctors to pull the claimant off of work or place them on light duty for a period of time. So often you'll see a 2-week off of work or a 2-week period on light duty or modified duty. The problem is if the follow-up visit is after that 2-week period, that will create a lapse to your entitlement to the benefits. So if you have off work for 2 weeks, but you're not going to see the doctor until 3 weeks later, you are going to have a lapse, a 7-day window where you'll be paid nothing. So it's critical to make sure that that lapse isn't there on the PPR. The easiest way to do that, make sure the restrictions that you have or the off-duty time that you have match the amount of time that's on the form when you're going to see the doctor next. Just make sure the dates are the same. Outside the 90-day window after you've selected your doctor, you can select a doctor in another way. That is, if the physician, your current physician, says that he or she can no longer treat you because you're required to see a different specialty or a different specialist, that doctor can then say, I want to transfer your care to another provider to provide that different type of care. If your physician does that, you have a new right to compel transfer of care to a specific different doctor of your choice. Another critical right in your medical benefits in the workers' compensation claims here in Nevada. Another aspect of medical benefits that are very important in the workers' compensation space here in Nevada is your right to select an IME physician, an independent medical examination. Prior to 2017, that right did not exist. A judge could send you to a medical examination. The insurance company could send you to a medical examination, but you as the claimant did not have that right. The legislature fixed that in 2017. They granted an independent medical right, an independent medical examination, called an IME for short. And you now have the right to pick a doctor to examine you to address whatever medical issues you're having. Over our many decades, we've learned which physicians in the community take good care of claimants and those that don't. So it's important to make sure that you select the right physicians to take care of you and your injury and your condition so you can get back to work and get healthy again. We commonly use the IME right or the IME physician to address all kinds of issues on an industrial claim, like what is the scope of your claim? What body parts should be included? Do you need surgery or not? Or should you be on restrictions or not? We use this to ascertain whether or not the treating physician on the case is taking proper care of you. Another powerful aspect of the IME, the independent medical examination right, is that we can use it anytime the insurance company sends you to a medical examination of their choice. So it's not uncommon for an insurance company to pick a doctor and send you to that doctor in an attempt to, in our opinion, derail the claim. Finally, the independent medical examination doctor, he or she does not have to be on the smaller or constrained insurance company panel list. We can use any doctor on the Division of Industrial Relations panel list, which contains hundreds and hundreds of doctors to choose from to do your independent medical examination. Let's talk about the monetary benefits that you're entitled to in a workers' compensation claim. First, there's TTD, temporary total disability. What does that entail? If your authorized treating physician on your claim takes you off of work or says you're not able to do full duty work at your job, but in a modified capacity, and your employer just doesn't accommodate that modified capacity, you are then entitled to temporary total disability, TTD. TTD is equal to 66 2/3 of your wage, up to a state cap. Now, those funds are not taxed. With regard to TTD, I've had clients ask me before, do I get the 66 2/3 and what does this cap mean? Well, it means if you make more than the state cap, then you will only receive 66 2/3 of that maximum wage of that state cap. So if you make more than that, you're not getting 66 2/3 of your gross wage, you'll be getting 66 2/3 of the state cap. An additional monetary benefit you may be entitled to in a workers' compensation case, the PPD, permanent partial disability. The PPD is typically what people think of as the settlement or the award or the payment at the end of the case. In order to get to a PPD examination, you must first be deemed medically stable or maximally medically improved by a physician. What this means is that in a period of 12 months from now, your condition wouldn't change regardless if you saw a doctor once a day or once in 12 months. That you have plateaued, stabilized, or reached maximum medical improvement. Once that has been obtained, you are then entitled to a PPD examination, a permanent partial disability evaluation. The permanent partial disability evaluation, the PPD evaluation, will be performed by a doctor that you've never met. This doctor will be randomly assigned or mutually agreed upon between us and the insurance company to do your examination. That doctor will then assess your injury or your illness and compare it to a guidebook required by law, the 5th edition Guides to Impairment. In that guidebook, it sets forth all kinds of injuries that happen to human beings and quantifies them in what we call whole person impairment, WPI. Think of this. You're 100%. If we take a piece of you away, that could be 1% or 5% or 10% or 20%. And what the examining doctor is doing is examining your condition, looking at your records from your industrial injury, and then assessing what was taken from you. How much percentage of your whole person is now gone as a result of that industrial injury. So you might have 5 points of impairment or 20 points of impairment. But the point is, that's how it's quantified in the industrial insurance system, the whole person impairment. And that is what the rating doctor is looking to assess in that examination. What is your whole person impairment? One of the many benefits that GGRM provides to its clients is that we have medical professionals on staff, actual physicians that are rating doctors, that will go with you to the PPD examination to make sure that your examination is true, correct, and fair. Once the whole person impairment, the WPI, is known by the rating physician, that number is then taken and put into a formula. That formula is statutorily based. It's not made up by you, me, the courts, the insurers. It's written into law. And what we do is we take the whole person impairment percentage, put it in that formula, combined with how old you were when you were injured, and what your wage was when you were injured, and out the bottom of that formula comes an award figure. That figure is your permanent partial disability evaluation award rating. The compensation award is calculated into a period of how many years between now and your 70th birthday. If you are 65 or older, it uses a factor of 5 years into the calculation. That calculation is then reduced to a present value. That present value can be taken in lump sum by you, the injured worker, for the first 30 points of impairment. So, for example, if you had a 35% whole person impairment disability rating, the first 30 points of impairment you would be able to take in lump sum right now. Those last 5 remaining points you would have to take in installments, either monthly or annually, until your 70th birthday. If your authorized treating physician on your claim indicates that you can't go back to work permanently in a full duty capacity, that is, your restrictions or your limitations are now worse than they were when you got injured and you can't do your original job, your company has a choice. They can either accommodate you, bring you back in permanent modified light duty, or they can send you off to the vocational rehabilitation training program. Vocational rehabilitation training by statute typically lasts anywhere between 9 and 24 months, depending on what your whole person impairment was on your case. Now, one of the important things to understand is that the counselor that assesses you is actually a choice you get to make. When you're in the vocational rehabilitation program, the Voc Rehab program, you are basically going to be receiving money every 2 weeks while you're being retrained. So whether the course goes on for 9 months or 12 months or 24 months, you'll be in school getting trained, but also be receiving that 66 2/3 of your max wage. Sometimes clients don't wish to go through a retraining program, and the law does allow for you to have a lump sum buyout of your Voc Rehab benefits, but it requires both the insurer and the claimant to agree to a Voc Rehab buyout. If either party doesn't agree, then there won't be a buyout, and you'll have to continue through the Voc Rehab program as originally planned. Workers' compensation claims in Nevada aren't designed to be open forever. In fact, most claims close at some point in their life cycle. So here's what happens. If the doctor has released you MMI, maximum medical improvement, you're stable, you don't need any more care, you've gone out to your rating, you've gone through the Voc Rehab training program, and all of it's been completed, your claim will close. Making sure your claim was positioned properly so that it is reopenable is one of the benefits that GGRM confers to its clients. To determine whether a claim is reopenable or not, you need to assess the following. Did you receive a PPD, a permanent partial disability rating evaluation of 1% or more? Were you incapacitated from earning your full wages for a period of more than 5 days? If the answer to either of those questions is yes, then your claim is reopenable for life. If the answer to both of those questions is no, then your claim is only reopenable for a period of 1 year. And finally, if your claim only involved $800 or less of medical care and you didn't receive a PPD evaluation of 1% or more and you weren't incapacitated from earning full wages for a period of more than 5 days, then your claim is not reopenable at all. One of the reasons a reopened claim is valuable is because the human body, while it may be stable, it can destabilize at some point in the future. You may need surgery to that body part that is predominantly due to the original industrial injury. That could be months or years later. Unlike a personal injury claim, when you sign your release, all your rights are extinguished. That just isn't true in a workers' compensation claim. These reopening rights are valuable, so it's critical that you have a law firm assisting you that understands how to close your claim so that it remains reopenable for the remainder of your life. Remember, if you have any questions on how to navigate the workers' compensation system in the state of Nevada, GGRM is here for you. Call us. We're happy to answer.